Good morning, everyone. I am Carol Williams with Williams Immigration, and we are back for another Monday morning edition of Beyond the Soundbite, where we talk about all things U.S. immigration. So, I like to dive right in. First thing I want to talk to y'all about this morning are the My USCIS online accounts. If you participated in the H-1B cap season this year, you know that there were some changes to not only the cap season, but there were some changes to the My USCIS accounts and to the capabilities of those accounts. So now USCIS is holding what they are calling tech talks. They have held several throughout the year on various topics. The next set that are coming up will be held on October 8th and November 5th, and they are going to specifically talk to us, to stakeholders, about the online accounts, about the My USCIS account. So if that is at all interesting to you and you've got some things to say or you want some opinions heard, feel free to hop on those calls with them. They are present, they are taking notes, and they do take suggestions back and tweak the systems. So again, if you're interested, the next set of tech talks by USCIS will be October 8th and November 5th, and they will be all about the My USCIS accounts. Next thing I want to tell y'all about is that Qatar will soon be a part of the visa waiver program. So the visa waiver program is for countries that their citizens do not have to go into the U.S. consulate in their home country and apply for a visitor visa. They have a streamlined system. They go online. It's called ESTA, E-S-T-A. They go online. They fill out the online ESTA form. If they are approved through ESTA, it is all electronic. Then they have a mobile app which they can now use. And so it means that they are allowed to come into the U.S. without having to get a visa. And we bypass the making an appointment at the consulate. We bypass the DS-160. We bypass all of that. So Qatar is the latest country that will be added to the visa waiver program list. And so the ESTA online system will be updated no later than December 1st of this year. So if you are from Qatar and you're looking to come in as a visitor, no later than December 1st, the ESTA system should be updated to allow you to do that. Also, going the other direction, U.S. citizens that are traveling to Qatar, we are already visa exempt when it comes to getting into Qatar. Currently, we are allowed in for 30 days. As of October 1st, that 30 days will increase to 90 days. So just keep that in mind if you are planning travel to Qatar anytime soon. Next thing I want to talk to y'all about are another set of delays. So I feel like I kind of maybe talk about delays in some way, shape, or form most weeks. But so this week, we're going to talk about delays in terms of the receipt notices. USCIS is backlogged. We know that it's taking them a while to issue the receipt notices. So they are now asking that we give them about 60 days to issue a receipt notice. Nobody wants to hear 60 days. Trust me when I tell you this. Nobody wants to hear that it's taking 60 days to issue a receipt notice. But the fact of the matter is we got to wait until CIS is not so backlogged on the front end of their own processing so that they can get us receipt notices. In my office, everything is filed via Federal Express. So we have the Federal Express tracking information that we pull for everything that is filed from my office. But keep in mind, it is taking USCIS longer in some instances to issue receipt notices. So we will just soldier on and hang on in there. The next thing I want to talk to you about also is an issue that happens at the front end of processing with the Immigration Service. So right now we have seen since the filing fees went up in April 1, a couple months ago, about 5-ish months ago, we have seen, my colleagues and I have seen an increase in applications that have been rejected by the mailrooms because of incorrect fees. Specifically, we have seen an increase in the rejection of I-140s. So the I-140s are part of the green card application. It can be the first or the second application, depending on your green card category and your method of filing. But we have seen an increase in those applications getting rejected. Rejected is a word that has a very specific meaning within immigration. Rejected is not the same as denied. Rejected in the immigration context is you file an application for whatever reason. In this case, immigration is saying that people are sending in the incorrect fees. That's why it's tied to this fee rule that we received in, the fee increase of October 1. We go ahead, we file an application. If the fees are incorrect, USCIS will send back the fees and the entire application. They will not receipt it in. So that is what rejection means in USCIS terms. So when an entire application comes back to you, we get generally a one-sheeter that says, incorrect fees. What it doesn't say is how the fees are incorrect. So it's this big old guessing game and looking at the new fee rule and trying to sort through that and figure it out. And, I do have colleagues that have sent, packages back multiple times because the Immigration Service refuses to tell us what exactly is incorrect about the fees. So we are all sorting through this issue. Many of my colleagues and I have become quite intimate with the April 1 Federal Register notice that increased the fees. But immigration has simply said, give us the correct fees and we won't reject your application until they recently released guidance. So 5 months later, they've released guidance on the fees because they realize that maybe it is actually a little bit complicated the way that they presented things to us. So there is guidance out there now. Hopefully that will help all of us, and we will see those rejection numbers going down. That is my hope for myself and all of my colleagues out there. The next thing I want to talk to y'all about are your dependents. So if you are here, and I get this call every so often, so I wanted to bring this to your attention. If you are here and you're a non-immigrant, let's say you're in an H-1B or you're in an L-1A, if you have a spouse and children with you, they have their own dependent visa categories. So they're going to be an H-4 or an L-2. If you as the principal file to extend your stay, and you do that while you're in the United States, your dependents must also file to extend their status if they are here with you in the United States. The dependents do not automatically get an extension based upon your filing as the principal applicant. So the dependents must file an extension application as well. If they do not, they run the risk of falling out of status. And that is no fun, frankly. So please file for your dependents to extend their status at the same time that you are filing for your own status. And if you've got some questions surrounding that, feel free to reach out to my office. We're more than happy to have a conversation with you about that. Last week, I talked about a hiring myth. So this week I have another one. And I do get this call quite a bit. The call generally comes in from an employer. They have this great employee. They've been on payroll for maybe a week, maybe two. They get a call from their payroll company. Payroll company says, hey, we cannot run payroll for this person. You probably need to have a conversation with your immigration lawyer. So then they call me because they don't have an immigration lawyer, right? And they say, hey, I can't, my payroll company says I can't put this person, I can't hire this person. I can't put them on payroll. I'm not quite sure why. They have a visa. So I start asking questions. And it turns out that usually that new employee is here in visitor status. So they entered the US lawfully they entered using a B1, B2 visa. And so they showed that to the employer, whether it been the recruiter or the person in HR or the person who was doing the I-9s or whoever it was at the company. They showed them this visa. And they said, hey, look, I have this visa. I'm here legally. And then the person completed the rest of the paperwork and hired them. So if someone is here on a B1, B2 visitor visa, that does not give that person work authorization. So it means that if you have someone who is here in visitor status, then you and I need to have a conversation to figure out what the best visa category is for that individual that allows them to work for you. So unfortunately, the Immigration Service and the Department of Labor are still going to hold you as the employer accountable if you continue to let this person remain on your payroll, even though you don't know or didn't know that they shouldn't have been working for you because they didn't have work authorization. So if you're unsure about an employee's visa status based on the documents that they are showing you, feel free to reach out to my office. Honestly, these are calls I get quite often, but it is usually someone that has entered on a visitor's visa and, kind of circumstances were what they were, and they lucked into a job and who's not excited about a new job. And, we just want to make sure that that excitement can be long-lived instead of someone coming in and saying, hey, this person's actually not work authorized. And I know you really are excited to have them on board with you, but you need to take them off payroll. So that is another myth that I wanted y'all to know, that someone that has, that they're in the US on a B1, B2 visitor, they are a visitor here. Visitor is a short-term status and they have to go back. But more importantly, while they're here, they are not allowed to work while in the US. So that is all I have for you this lovely Monday morning. If you have any questions about your immigration case or what is going on, if you think maybe you've hired someone that may be in visitor status or you're just not quite sure, feel free to reach out. More than happy to help. I'm Carol Williams with Williams Immigration. Have a beautiful rest of your Monday and a fantastic